This courtroom quickly became a test of accountability. Defendants with long criminal histories faced strict probation, denied bonds, and house arrest. No excuses. The court made clear that behavior has consequences.
And Ms. Hill, in cause number 25 DCCR 0650, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of assault family violence by impeding breath or circulation. Sentence you in accordance with your agreement to a term of 10 years in prison, but I'm going to probate that. You'll be on probation for 10 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. One of those conditions is going to be that you enter and successfully complete the Special Needs Safety Program. That is intended to help you with everything that's going on in your life, any mental health treatment you need, as well as substance abuse treatment, so that when you get out, you'll be better equipped to be successful on probation. And so if you do everything that you're supposed to on this probation, then for all practical purposes, your case here in court is over. You'll be able to serve that 10-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you can be brought back in here and you'll be looking at that 10-year sentence that you've already agreed to. Do you understand? Also, it's very important that you understand you can have no contact or communication with Cheryl Johnson. That's in person, that is electronically, through messages, or anything like that. Do you understand? And even if she gives you permission and says, oh, it's okay, I'm not giving you permission, and that's how that has to work. You understand? All right, so I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your rights to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. And so Mr. Hancock is charged in 25 DCCR 0737 with evading arrest or detention with previous convictions. Cause number 25 DCCR 0738 with continuous violence against the family. And then there's a third case, and those both have offense dates of April, well, first one is April 22nd, 2025. Second one is April 26th, 2025. And then in cause number 25 DCCR 1233, there's a new evading arrest or detention with previous convictions from August 5th of 2025 that has now been indicted. And Ms. Holmes has filed motions in the first two cases asking that I reduce Mr. Hancock's bonds, which are currently set at $100,000. It looks like there was a court date on July 22nd, 2025 that Mr. Hancock missed, and so that was when those bonds were increased. July 22nd? Mm-hmm. And then, so he missed court on that date. So there it was, before that, there was an AFRS that was filed by the bondsman to get off the bond. But when he didn't show up, bond forfeiture overrides that. And so that was bond forfeiture. And then also, since then, there was a request for an emergency protective order. Oh, that was just filed. Okay, looking, that was from back in arrest on, where's the date? April 20th. Okay. So, also reviewing jail incident report that I have received. Have you had an opportunity to review those? Yeah. Why don't you take a look at those, and then before you try to make arguments on behalf of your client who's making things very difficult for you, y'all can go review those, and then we'll come back and discuss the bond. I've already know what I'm going to do, but I'd be glad for you to do that as well. Okay.
He's habitual, considering family case. She has a total of $25. She evaded to jail. The way with her conviction, she has a total of 8 months. Like 3 months still up when he was arrested in August, while he went to his kids. And prior to not evading include firearms, drugs, and
Right. Home.
he had only been off parole 2 months before he knew off.
I'm going to see what the bond is set at on the new case 25 DCCR 1233. Because honestly, based on everything I'm seeing, I'm not sure the bonds are. So, with Holmes, any
So, Your Honor, I was provided some documentation. Apparently, Mr. Hancock did go to the hospital in July, which I believe he did provide that documentation to the bondsman. I'm not sure if he was aware that the FRF had been filed at that point. He is aware that he needs to pay in the jail.
really, you're aware of that? How old are you? You're 36 years old, so you needed to come here today and have her tell you you need to behave in jail? This is ridiculous. These people are just going to work and trying to do their job. That's all. You know, I mean, that's what the rest of us do. We go to work, we do our job, we go home, we live our life, and we don't have punks like you acting like this and treating us this way when we're at our job. The way you have spoken to the officers, the female, they disrespect you first. You think you earned their respect? You're in jail. You follow the rules. Their job is just to do their job. If it's time, you don't get to make decisions in jail. You don't get to decide when you turn the lights on and off. You don't get to decide when you go to bed or when you eat. It's not your decision anymore. That's what happens when you continue to violate the law. You've lost your right to make those decisions. So it's their decision to try to keep everybody in order out in the jail the best they can. And the way you have spoken to them and threatened them is actually a violation of the law, and you could end up with more cases for threatening a correctional officer. So just keep going. Keep stacking it up. I'm sure a jury later will love to hear all of that. They'll love to hear it. You're looking at 25 to life for one of your cases. Keep it up. Let's see what happens. Because a jury will see all of this.
Repeated missed court dates, jail incidents, and prior felonies stacked up against the defendants. Bond reductions were denied. GPS monitoring and house arrest were enforced. The court emphasized public safety above all.
And if you think I'm going to take some great deal that they're going to negotiate, or you think Mr. Nichols is going to give you some great deal, it's not happening. So you're old enough to know better. I'm going to deny the motions for bond reduction in clause numbers 25 TCCR 0737 and 0738 based on several factors: your criminal history, the fact that you did miss court, the fact that your bondsman had already filed an AFRS, your jail incident reports. I am also going to find in clause number 25 DCCR 1233 that your bond is insufficient. And in that case, I'm going to raise your bond to $100,000. Condition of all of these bonds, if you make them, will be that you will be required to wear a GPS monitoring device and you will be on house arrest. So if you make these 3 bonds, you will be on house arrest. You're not allowed to leave your house unless you have my permission. And you will be also ordered, and it should already be in the bond condition in clause number 25 DCCR 0738, to have absolutely no contact no communication at all with the complaining witness. Do you have that name handy? Janaisha Butler? Janaisha. So you cannot have any contact whatsoever with that person. Do you understand? That also includes when you're in jail. So there's no sending messages through that email system or anything like that to anybody else. That'll be a violation of your bond, and your bonds will end up raised even more. You understand? All right, I'll reset it for an announcement. We'll deal with all of the cases at that time.
Thank you.
Thank you. Mr. Godinez, in cause number 24, DCCR 2040, you're charged with a second-degree felony of aggravated assault with a deadly weapon from August 29th, 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Wilkerson?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving and giving up any right to appeal?
I understand.
Also, do you understand, if you're not a United States citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization to the federal? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Godinez is not competent?
No, Your Honor.
Mr. Godinez, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 12 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will be an affirmative finding of a deadly weapon. I'm going to hand you the trial court certification. This shows that this was an agreement that I followed, so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. That's in Spanish, so you should read it carefully. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or how long that lasts, you can talk with Mr. Wilkerson. Yes, sir?
We've included in the paperwork that we take from the family standpoint, you can see that. Don't realize
Okay. So, consecutive. So, Mr. Godinez, I want to make sure you understand that this sentence will run consecutively with any federal.
Probation conditions, consecutive sentencing, and firearm restrictions were all explained on record. Refusal to comply or continued violations will have serious legal consequences. The court moved forward, and the rulings are final.